Hello, everybody. For those of you I don't know, I'm Bob Levy, Chairman Emeritus at the Cato Institute, a libertarian think tank in Washington, D.C., devoted to defending private property, free markets, individual liberty, and limited government. Today, I'm going to examine a long list of proposals by Donald Trump to expand his own powers and those of the executive branch. Mostly, I'll be discussing what he can and cannot do as a matter of law, which is different than asking whether his ideas are good or bad as a matter of public policy. It's possible, of course, that a program can be both good for the country and yet illegal. When that happens, we can't ignore the law. The options are either change the law or modify the program. Okay, let's start with one of Trump's most controversial directives, which could have a huge economic impact. Can President Trump impose tariffs without congressional approval? Arguably, recent laws give presidents substantial authority on tariffs, but the Supreme Court has ruled that Congress's delegation of authority must be explicit on all matters of major importance. The statutes in question relate only to national security, emergencies, and serious unfair trade practices. So, blanket across the board tariffs without approval by Congress are probably void, as are, for example, assessments to compensate for damages from fentanyl. In addition, our trade agreement with Mexico and Canada, negotiated by Trump in 2020, provides for duty-free transactions among the three countries, so any new tariffs will surely be challenged. Trump says he just wants a level playing field, that is, reciprocity. But the World Bank reports that the average U.S. tariff before the Trump blitz was 2.7%. That's higher than approximately 2% for Canada, Japan, Europe, and Mexico. Ideally, reciprocity should involve tariff reductions, not parallel increases. Next topic, can the president bar the Associated Press from a briefing for not using the label Gulf of America? The consensus is that the president is empowered to change the names on U.S. maps, but Article 4 of the Constitution states that Congress shall have power to make all regulations respecting the territory or other property belonging to the United States. More importantly, punishing the AP for not using Gulf of America may well be viewpoint-based discrimination, a clear First Amendment speech violation. The administration's counterclaim is that the AP is spreading lies. That's not very persuasive since misinformation is constitutionally protected speech. There are, of course, legitimate ways of restricting access to a press conference that obviously has limited capacity. For example, a background security screening, adherence to rules of conduct, seniority, circulation size, qualification as a legitimate member of the press. Trump could have used any of those without objection, but he did not. As you've no doubt read, Trump is also punishing major law firms to retaliate for their involvement in prior Trump prosecutions and other litigation that he opposed. The firms are being denied security clearances, access to government buildings, and federal contracts. That definitely raises both Sixth Amendment right to counsel issues and the same viewpoint-based First Amendment speech problems as the Associated Press dispute. Frankly, the matter is not a close call, and the federal court said so on May the 2nd. In addition, Trump has withheld federal research funds from Columbia, Harvard, Princeton, Cornell, Brown, the University of Pennsylvania for failing to combat anti-Semitism and other policies that Trump finds distasteful. But by law, withdrawal of educational funding requires a hearing and written report to Congress, and cancellation of funds can affect only the offending program, not the entire university. Under Title VI, which applies to recipients of federal funds, the government might be able to induce colleges to discipline students who violate anti-discrimination policies. But that doesn't extend to Trump's other directives ordering universities to review faculty plagiarism, reduce governance bloat, and ensure viewpoint diversity. Even if Congress had those powers, the president does not. Nor can he revoke a university's tax-exempt status. Only the IRS can do that. Section 501c3 of the tax code says religious, charitable, and educational nonprofits are tax exempt unless they participate in political campaigns. To the extent that Harvard and other colleges are being punished for condoning anti-Semitic expression, that is plainly viewpoint-based discrimination. To the extent that Harvard itself discriminated, the revocation of its tax exemption may be far too severe. Can the president eliminate DEI programs? Trump has ordered that federal grants and contracts be withheld or canceled for entities that have implemented diversity, equity, and inclusion programs on the ground that they violate anti-discrimination laws. DEI programs, according to Trump, run afoul of the 14th Amendment's Equal Protection Clause and Title VI of the Civil Rights Act, which again applies to organizations that receive federal funds. Ammunition for that argument came from the Supreme Court's recent affirmative action cases involving Harvard and the University of North Carolina. The court held that race could not be used as an admissions criterion to achieve a diverse student body. An opposing argument endorsed by federal judges in Maryland and Illinois is that Trump's executive order is textbook viewpoint-based discrimination, suppression of speech based on the position taken by the speaker in violation of the First Amendment. Both judges temporarily halted enforcement of Trump's executive order. They concluded not only that it threatened the expression of views supportive of DEI, but also that lack of clarity violated Fifth Amendment rights to due process. Can the president bar transgender females from competing in female sports? Proposed Department of Education regulations cover schools that receive federal funding. Here are the legal issues. Number one, is the federal government constitutionally authorized to regulate education? Remember, Trump wants to close the Department of Education, in part because the 10th Amendment says that powers not listed in the Constitution are reserved to the states. Number two, can the president deny funding to private schools that don't comply with his executive order? Probably not if the denial is considered to be coercive or if the funds are for programs other than athletics. Number three, does Title IX of the Civil Rights Act, which bars discrimination by sex, also bar discrimination by sexual identity? Number four, can the president direct his Department of Education to implement these regulations without congressional approval? Again, probably not, unless the statute grants such discretion to the president. And by the way, there are similar cases pending in the Supreme Court regarding transgender military service and access to medical treatment and counseling. Can the president impound congressionally appropriated funds? Trump has suggested that he would resurrect impoundment as a means to control federal spending. Under the Impoundment Control Act of 1974, the president can opt not to spend money that's been appropriated, but first, he would have to submit a rescission bill to Congress, which must be approved by both houses within 45 days. In the past, Congress has rejected most of those presidential requests. Still, all recent presidents, from Reagan forward, supported impoundment, as did many politicians from both parties. The Supreme Court hasn't ruled on the constitutionality of the 1974 statute. More litigation is likely. Arguably, the court might review Trump's freeze or delay in expenditures differently than it would view impoundment, which is a refusal to spend. Unless a statute has a specific date by which dollars must be spent, the president might be justified in postponing spending until he can certify that it complies with other laws and executive orders. Next, we turn to agency-related issues. Can the president exert control over so-called independent agencies? A Trump executive order published in February imposes presidential supervision over independent agencies such as the SEC, FCC, FTC, and the CFPB that are supposedly separate from the executive branch, even though they have law enforcement authority. Trump's justification is that Article 2 of the Constitution directs the president to take care that the laws be faithfully executed. Under Trump's order, the agencies would have to submit proposed and final rules, which would be reviewed within the White House for conformity to the president's agenda. One goal, among others, would be to increase accountability by substituting an elected official, the president, for unelected agency heads. That would represent a major, and in my view, long overdue change in governance, effectively reinstating the framers' original design that established 3 branches, not 4. Note that many of these independent agencies also exercise legislative power, so the corollary to a presidential control over their executive functions would be congressional control over their legislative functions. That is, a restoration by Congress of the lawmaking role that Congress abdicated in favor of the administrative state. One sticking point, the Federal Reserve. Ideally, monetary policy should not be dictated by the president. Perhaps the solution is to divide the Fed into an executive agency that regulates the banks under presidential control and a separate entity that sets monetary policy under congressional control. Okay, turning to the Department of Government Efficiency. Is DOGE legal? First, there's Elon Musk. His access to confidential information may have violated various privacy and national security regulations. He was designated as a special government employee, which limited him to 135 workdays in any year through the end of May. He was also subject to criminal conflict of interest laws that bar involvement with government matters that could affect his personal interests. That is, for example, government contracts. And if he was deemed to be an officer of the United States, he should have been confirmed by the Senate. Second, there's DOGE itself. Trump characterized DOGE as an advisory entity. As such, it would be subject to the transparency rules of the Federal Advisory Committee Act. And that act also limits any authority that can be exercised by private parties, such as Musk. However, one judge said that DOGE is not merely advisory, but is an agency and can therefore access selected government data. But the judge noted that agency status also subjects DOGE to the Freedom of Information Act, the Privacy Act, and the Administrative Procedures Act. As an agency, DOGE could do more than render advice. It could exercise limited authority. Even then, DOGE could not spend or impound money without approval by Congress. Can the president close an agency, for example, USAID, the Department of Education? Yes, but only under these conditions. Number one, the agency is authorized by executive order, not by statute. Or number two, the statute establishing the agency is unconstitutional. Or number three, the statute gives the president termination discretion. Or number four, the agency is authorized for a limited period. None of those conditions apply in this instance. On the policy side, closing the Department of Education would be, in my view, no loss. First, it's not constitutionally authorized. As far back as 1817, James Madison noted that, quote, the power to legislate in education is not among the federal government's enumerated powers. Second, since the Department of Education's inception in 1980 as a political payoff to the teachers' unions, the department has accumulated a $1.7 trillion loan portfolio and issued edicts on everything from transgender bathrooms to COVID mask rules. What the department hasn't done is improve academic performance of U.S. students. Can Trump defund the Corporation for Public Broadcasting? Taxpayers currently provide $535 million annually to fund PBS and NPR, roughly 10 to 15% of their budgets. In my view, public funding is an unwarranted intrusion by government into functions adequately performed by the private sector. Moreover, the net result is to transfer wealth from less affluent persons, most of whom do not watch PBS or listen to NPR, to more affluent persons, many of whom patronize both services. Nonetheless, good ideas have to be implemented in a manner that complies with our laws and the Constitution. Trump complains that PBS and NPR don't present a fair, accurate, unbiased portrayal of current events. But for him to condition funding on his personal assessment of objectivity is a blatant First Amendment speech violation. Government may not discriminate against speech based on the viewpoint expressed by the speaker. Additionally, Congress established the Corporation for Public Broadcasting in 1967 as a private, nonprofit corporation independent of the federal government, and Congress barred federal officials from controlling the corporation or its grantees. That means the president can't act unilaterally without congressional approval. Can the president remove agency heads? The Constitution covers appointment of administrative agency heads, but not removal. Until 1935, the president could fire subordinates freely. But in Humphrey's Executor versus United States, the Supreme Court held that the Federal Trade Commission, an independent agency, did not primarily exercise executive power. So if the president, who heads the executive branch, wanted to remove an FTC commissioner, he could do so only for cause, that is, incompetence, neglect, malfeasance. But then in 2020, Seal of Law versus the CFPB, Chief Justice Roberts held 5-4 that removal only for cause would violate the separations of power principle because the CFPB was headed by one director with substantial executive power, and the president is the chief executive. Accordingly, Congress may not restrict the president's removal discretion unless, number one, he's removing inferior officers who have limited duties and no policymaking or administrative authority, or number two, the agency is headed by a bipartisan commission appointed to staggered terms, performing mainly legislative and judicial, not executive functions. Can the president fire government employees and bypass civil service regulations? In January, Trump fired lower-level employees, FBI agents, Department of Justice attorneys, and inspectors general, who are part of his executive branch. But they may be protected by contract or by civil service regulations, and federal law requires written reasons plus 30 days notice to fire inspectors general. Alternatively, Trump offered to buy out the contracts. That received a green light from the courts, as long as it didn't require new funds. Unions are also challenging Trump's Schedule F reform, which would reclassify some high-ranking career employees and remove their civil service protection. There, the president may have a decent legal argument. The Civil Service Reform Act of 1978 exempts positions determined to be of a confidential, policy determining, policy making, or policy advocating character. Our next category of issues relates to immigration. Can the president eliminate birthright citizenship? The 14th Amendment states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. The goal was to overturn Dred Scott, an 1857 case, which denied citizenship to slaves and their kids. The framers added the phrase, subject to the jurisdiction, to deny citizenship to two groups, children of foreign diplomats and children of enemy forces occupying the U.S. Neither group was subject to our jurisdiction, but Congress surely did intend that children of permanent legal residents would be citizens. Indeed, the Supreme Court said so in U.S. v. Wong Kim Ark in 1898. Still, that didn't resolve the status of temporary resident aliens, for example, students and tourists, and illegal aliens. They are subject to our laws, at least while they're here, and they can be convicted of violations. So a natural reading of the phrase, subject to our jurisdiction, suggests that their children are citizens. But in 1868, when the 14th Amendment was ratified, there were few, if any, restrictions on immigration. So birthright citizenship wasn't about illegal aliens. The phrase subject to our jurisdiction might have meant primary and permanent allegiance to U.S. law and sovereignty. On the other hand, Confederate soldiers were not allegiant to the U.S., and yet their children were clearly citizens. And many victims of the slave trade had been brought here involuntarily and illegally since 1808. Their allegiance was surely questionable, but their children were also among the intended beneficiaries of the 14th Amendment and birthright citizenship. Further, in Plyler v. Doe, involving illegals' access to education, the court said there was, quote, no plausible distinction with respect to 14th Amendment jurisdiction between resident aliens whose entry into the U.S. was lawful and resident aliens whose entry was unlawful. My sense of the constitutional question goes like this. If Congress were to deny citizenship to children of illegal and non-permanent aliens, a conservative Supreme Court might, but probably would not, uphold that law. It is even less likely that the court would uphold a unilateral declaration by the president without parallel legislation. Can the U.S. deport aliens for advocacy of causes that are contrary to U.S. policy? The Trump administration arrested Mahmoud Khalil, who advocated for Hamas in protests at Columbia University. The White House stated, the allegation here is not that he was breaking the law. Instead, Khalil was, quote, mobilizing support for Hamas and spreading anti-Semitism in a way that is contrary to the foreign policy of the United States. Question number one, did Khalil's conduct or his speech trigger the administration's actions? Secretary Rubio did not cite any specific behavior apart from Khalil's advocacy that would justify deportation. Accordingly, Khalil's punishment would seem to cross the line into viewpoint-based speech suppression. Importantly, the Supreme Court ruled in 1945 that freedom of speech is accorded to aliens residing here. The Immigration and Nationality Act, INA, allows deportation if the secretary has, quote, reasonable grounds to believe that an alien's acts would have potentially serious adverse foreign policy consequences. But there's an exception. No removal on account of, quote, the alien's beliefs, statements, or associations, unless the Secretary of State personally determines that the alien's admission would compromise a compelling U.S. foreign policy interest. So, question number 2, did Rubio personally make such a determination? Question number 3, based on what evidence? Question number 4, is the INA's trigger, quote, potentially serious adverse foreign policy consequences so vague as to be unenforceable? And question number 5, does the statute deny due process, that is, an opportunity for the alien to be heard and contest the allegations? Relatedly, on March 26th, the D.C. Circuit temporarily halted deporting Venezuelan gang members under the Alien Enemies Act. That act is applicable to countries at war with us. It hasn't been used since World War II, the Japanese internment case. Drug gangs are not a country or controlled by a country. We are not at war with Venezuela, and illegal immigrants are not mounting an invasion or an incursion to seize power in the United States. Indeed, if they were, the president could suspend habeas corpus, even with respect to U.S. citizens. The administration's counterarguments are not very persuasive. Number 1, the judge's order wasn't in writing, a debatable rationale. And number 2, the plane removing the immigrants was in international airspace when the order was issued. That's not relevant if the alleged gang member was in U.S. custody on a U.S. plane. Bottom line, government must not have free rein to arrest, detain, or deport any non-citizen accused of criminal acts without due process. On April 7th, the Supreme Court agreed 9-0 that due process is required. Thus, the flights to El Salvador were unconstitutional. The court didn't reach the question whether the Alien Enemies Act applied, but 12 days later, on April 19th, the court, 7-2, did temporarily halt deportations. Then district courts in Texas, New York, and Colorado, they have now ruled that Trump may not use the act to send aliens to Venezuela or Libya. What about Abrego Garcia, who was deported in error to a prison in El Salvador? Will he be returned to the United States? The White House alleges that Garcia is a leader of the MS-13 gang, but hasn't produced any evidence in court. Garcia denies gang membership. A federal district judge ordered the administration to return Garcia before April the 8th, and the Fourth Circuit Court of Appeals, citing denial of due process, rejected the government's bid to delay that deadline. And then the Supreme Court, on April the 10th, ordered the administration to facilitate Garcia's release. Trump claims it's all up to El Salvador's president. Meanwhile, continued payments of $6 million to El Salvador obviously did not facilitate Garcia's return. So, on April 15th, the district judge ordered expedited discovery to determine if and how the administration was complying. Trump appealed. On April 17th, the Fourth Circuit unanimously rejected the appeal. A highly respected conservative judge, J. Harvey Wilkinson, wrote that the government would, quote, stash away residents in foreign prisons without the semblance of due process. Next step, another trip to the Supremes. Can the president deport U.S. citizens if they've committed a crime? Federal law requires the Bureau of Prisons to provide suitable quarters and safekeeping care and subsistence. Even for-profit prisons have to afford similar constitutional protections. So, no, under current law, U.S. citizens cannot be deported to places that might even violate the Eighth Amendment's ban on cruel and unusual punishment. Finally, a couple of court-related issues. First, can a single district judge issue nationwide injunctions? That question has been marinating in the courts for a while, and it's not yet settled. A March 31 bill by Chuck Grassley would bar nationwide injunctions against the executive branch by non-parties to the lawsuit and make temporary restraining orders against the government immediately appealable. But some situations require national uniformity. For example, building a border wall, regulating social media content, restricting mail order access to certain products. The resolution of those issues cannot be limited to specified parties or jurisdictions. Probably a better solution would be for Congress to bar a national injunction by a district judge unless it's needed to fully remediate an injury or until it's affirmed by an appellate court. Meanwhile, Trump has been enjoined more than 100 times, versus 24 for George W., 38 for Obama, and 28 for Biden, although that's probably because Trump has issued so many more executive orders. In response to more than 100 injunctions against him, Trump has called for the impeachment of federal judges. He's called them lunatics, guilty of sedition and treason. Speaker Mike Johnson threatened to eliminate or defund judicial districts. Elon Musk called the rulings against Trump a judicial coup. Stephen Miller warns of naked judicial tyranny. J.D. Vance stated that judges aren't allowed to control the executive's legitimate power, obviously begging the question of what's legitimate. And Republican lawmakers have filed articles of impeachment against several federal judges. From my perspective, those actions are provocative, misguided, and dangerous. What's the recourse if the president ignores a court order? Subordinates who disobey court orders can be held in contempt, fined, and even disbarred. Yes, the president can pardon any criminal conviction, but not civil contempt, which could mean, but probably wouldn't mean, jail time. Under Justice Department guidelines, a sitting president can't be prosecuted. Ultimately, redress would have to come from the voters at the polls, from Congress through impeachment, from a cabinet mutiny under the 25th Amendment, or by prosecuting the president after he leaves office. The imperial presidency has indeed become a problem, but the problem predates the recent power grabs by Donald Trump. Nixon exceeded his tariff authority in 1971. George W. exploited national security powers after 9/11. Obama refused to enforce marijuana laws and took actions on immigration that he admitted were unauthorized. Biden abused the pardon power and tried to cancel $500 billion in student loans. When the Supreme Court said no, Biden conjured up alternative means to bypass the court. And it was Biden's Labor Department that unsuccessfully claimed unilateral authority to mandate vaccinations by all large private sector companies. He had the enthusiastic backing of congressional Democrats, willingly condoning executive overreach because their man was in the White House. So the problem goes beyond Donald Trump. The root is congressional abdication. The answer? Congress has to reassert its authority as a co-equal branch and revitalize its oversight and lawmaking roles as envisioned by the framers. That's it for today. If you'd like to know more about the Cato Institute, please visit cato.org on the web. Many thanks for your time and attention.